I respectfully reserve 5 minutes of rebuttal. My name is Andrew Crawford. I'm here on behalf of the appellant and the defendant in this case, Vincent Roberson. This case comes to this court after an evidentiary hearing, a partial evidentiary hearing on a motion for post-conviction relief after conviction for aggravated battery involving a firearm and a subsequent 20-year sentence. There are 3 issues in the brief that I would like to discuss with the court this morning. The first issue being the trial court denied an evidentiary hearing when there was evidence presented in the motion for post-conviction relief that the alleged victim complainant in this case offered to drop the case in exchange for $20,000. He was questioned during the trial by defense counsel about whether or not he had made this statement to another individual who was the landlord, the defendant's landlord in this particular case. He denied such a statement. Under the de novo standard of review that's present as it relates to this first issue, I submit to the court that this was error. The statement provided a civil motive for...
Can I get on the same page?
Yes, sir.
Mr. Reedus citing?
Correct, John.
I thought you were not pursuing the denial of claim 2A.
No, sir. I am pursuing that.
Okay.
Yes, I'm absolutely pursuing that as it is alleged specifically in the brief as well in the initial brief.
What's the substantive issue that would have been admissible or independent of the impeachment?
Independent of the impeachment, that goes directly to a civil motive to falsify, which the jury is instructed on prior to closing arguments. In this particular case, not only do you have a motive to falsify, or civil motive in this case, which is money, but you also have a prior inconsistent statement. The issue really for the court and what the lower court did was they made a determination that that statement went to a collateral matter, and therefore it was not admissible by Mr. Saad testifying at the substantive trial. I take issue with that ruling, specifically citing to the Roberts case, which is a 2018 case that this court found involving a capital sexual battery case, which had a very similar issue. In that particular case, there was evidence alleged in the motion for post-conviction relief that was summarily denied that the defendant in that case had been asked by one of the alleged victims to give him $20,000 to start a restaurant.
How much of this goes to discretion that the court says, hey, it's collateral and we get to review a discretionary call by the trial court?
Absolutely. It's a de novo standard of review. And this is
Why is it de novo?
It's de novo standard of review because it was denied without an evidentiary hearing. Therefore, this court, as the appellate court and the trial court, has to assume that the facts alleged in the motion are true, unless conclusively refuted by the record. And in this particular case, there's nothing in the record to absolutely refute that fact other than the Mr. Barron's statement that he never made the statement. There would have been a witness, as alleged in the motion, who would have testified to the contrary, that he offered to drop the case, or at least go to the prosecution and drop the case, offer to drop the case if he was paid $10,000. You know, that is a very strong civil motive. Furthermore, a criminal defendant has a Sixth Amendment right to confront his accusers or any witness against him at trial. Inherent in that Sixth Amendment right is a right to expose a witness's bias, interest, or motive.
Just for my ratification, was the argument nonetheless made to the jury in this case, even though the evidence didn't come in the way you wanted it to, or whoever the trial attorney was?
The argument, to my recollection...
The argument today, was that made to the jury? This guy was going to be bribed off, and therefore there's a motive here to lie.
No, I don't believe it was, Your Honor, because...
You're telling us for the first time appeal, but it was argued to the trial judge, and the trial court said it's collateral, and that's what you're taking issue with.
What I'm taking issue with is the alleged victim in this particular case was specifically asked during the trial whether or not he had offered to drop the case in exchange for $10,000. He denied it, the inquiry was stopped, and then on the motion for post-conviction relief, it was further elaborated why that question was asked. I don't think it was really mentioned in the trial court below.
There was a proffer made at some point.
There was not a proffer made. It's solely a post-conviction issue. because there was not a proffer made in the trial court. This is not something that could have been.
I just want to clarify one thing. I think in the state's brief, they framed it as that the victim denied that he was offered money, but that's wrong.
That's wrong.
Okay.
That's absolutely wrong.
I just want to make sure I thought that was maybe a mistake.
That's absolutely wrong. What happened was the alleged victim in this case, who lived in the neighborhood where this restaurant was, approached the landlord of the restaurant and said, "Hey, tell the Roberson family I'll go to the prosecution. I'll drop this case if they pay me $10,000," which is a much different scenario than described.
And the post-conviction court's conclusion was that he wasn't prejudiced because that wouldn't have been admissible.
Exactly.
And your position is that there needed to be an evidentiary hearing?
Correct.
Okay, so I'll put on my post-conviction thinking cap. So if you assume the facts are true, that this witness would have testified that he heard this offer, can't the post-conviction court assume that was true and make this conclusion that it would have been inadmissible? I mean, what would be developed at an evidentiary hearing that wasn't before the post-conviction court when it made that determination?
Well, Judge Kelly, there's two issues there. The first one is the evidentiary issue. The second one is what would come out at an evidentiary hearing. So as to the evidentiary issue, which again is a application of the facts to the law, the facts to the law, that is a purely de novo standard to review in this case.
Right.
And the question becomes whether or not that type of statement can be used as impeachment or whether it's collateral. That's a legal issue for this court.
Right. I understand that. But I'm trying to understand, I mean, I think the thrust of your argument is there should have been an evidentiary hearing on this.
There should have been. It could have been further flushed out, the exact contents of the statement, what the statement was specifically.
And would that have made a difference, you think, or potentially could make a difference in the trial court's determination as to whether it was collateral?
Yes, I think it absolutely could. But taking that one step further from a purely legal perspective, the question of whether or not a statement like that is collateral, this court specifically addressed in the Foster case. And in a case such as this, where you have two groups of people who testify that provide completely different narratives of events, credibility was a crucial determination. And when you're determining credibility, every little factor, especially the credibility of a key witness, which was the alleged victim in this case, is paramount. Not only did the jury not hear about this, they didn't hear about the felony convictions, which we'll talk about in a minute with the court's permission, but this would have directly gone to his bias, interest, motive. And an evidentiary hearing could have further flushed that out.
So would it be fair to characterize your argument as, look, we don't even need to reach the issue of whether or not it's collateral, we don't get there yet, because we just, given the allegation, there should have been an evidentiary hearing, and once there's an evidentiary hearing, then the trial court can make this determination about whether it's collateral or no?
I think from a legal perspective, based on what was specifically, the trial court in its ruling made a purely legal determination that this was a collateral, and even if it is true for the sake of argument, it could not be used as substantive impeachment.
Therefore, no prejudice.
Therefore, no prejudice. And it's conclusively refuted by the record. I think this court can make a legal determination that that's not collateral, and therefore remand for an evidentiary hearing, which should take place in this particular case.
Refresh my memory, how is it, what in the record would have conclusively refuted it?
Nothing that I'm aware of.
Okay, but you said the trial court found that.
Well, the trial court found that it was not admissible, therefore there wouldn't have been prejudice.
Got it. Okay. All
So,
right. Just want to make sure I understand this.
and the trial court makes a purely legal determination, which, again, based on the Foster case and the Roberts case, which I cite to this court, it's not a collateral issue because it goes to a civil motive and also goes to a prior inconsistent statement both of which the jury was specifically instructed on in this particular case when determining credibility to weigh those two
Credibility
things.
is really important
It,
in
it,
this case.
it was extremely important for this case.
Yeah.
So you have that first issue. Then the second issue, which is a mixed standard of review because there was an evidentiary hearing on issue number 4, which was the failure to impeach with the felony convictions. And that standard review, again, the application of the law is de novo, but this court is supposed to defer to the trial court's factual findings unless those are refuted by competent substantial evidence. As long as they're supported by competent substantial evidence. In this particular case, we have trial counsel getting involved the day before the trial is to start, moves for a motion to continuance. The judge grants the motion for continuance. Comes to court the day of the trial, again, I would argue unprepared. A deposition is taken at some point either by the public defender's office or the Office of Regional Counsel of the alleged victim, in this case, Mr. Barron. He specifically admits to felony convictions and a crime of dishonesty. It's there, it's in the deposition, which was taken on March 26, 2015. And then during the evidentiary hearing, counsel admitted that he read the deposition and he should have impeached Mr. Barron with his felony convictions. The question wasn't even asked. So again, when it comes down to credibility, the question, the trial court found there was although there was deficiency here, which is not specifically found.
Because it was remote?
Correct, because it was remote and the state could have, further rehabbed the witness by saying they weren't nonviolent felonies and actually gone into the facts of the felonies, because I believe some were driving on suspended license, one was petty theft, one was possession of cocaine. But to be clear, there's 2 felonies and 1 crime of dishonesty. Nevertheless, that is 2 things that the jury is specifically instructed on.
The point isn't about being crimes of violence, isn't it just going to credibility again?
Yeah, again, it's exactly right. It's a credibility issue.
You're talking about this witness who didn't get to testify about the bribe, potential bribe.
No, sir, I'm moving on to the 4th issue, where the alleged victim in this case of the shooting was not impeached with 2 prior felony convictions and 1 prior crime of dishonesty that defense counsel knew about, admittedly, at the evidentiary hearing, but chose not to impeach the witness on. He did not provide any type of strategic reason for not doing that. He merely said, I should have done it.
He said, I should have.
I should have, but I didn't. So really it becomes whether that prejudiced Mr. Roberson during the trial. As in a case.
And I think your argument is given the importance of credibility in this case.
Exactly right. You're left with a group of witnesses against another group of witnesses, and the person who was actually shot was not impeached, not only with the offer to drop the case for $10,000, but was not also impeached with his prior felony convictions and a crime of dishonesty. Again, something that the jury is specifically told to weigh when determining someone's credibility. And when you have 2 different versions of events of what happened in a case this crucial, where there's a 20-year minimum mandatory sentence, that should have been done in this case. And I would submit prejudice occurred from the failure for that to take place. That would again bring us to the cumulative error that was specifically alleged.
Before you go to
Sure.
cumulative, could you just touch briefly on the readback issue?
Certainly. So during the trial and during deliberations, again, there was one group of individuals who said a way the shooting went down, which in their version was not self-defense, which was Mr. Barron and his brother. Then there was a second group of individuals, which included the defendant, Vincent Roberson, his family members, who said the shooting was in self-defense. So you had 2 diametrically opposed versions of events. During jury instructions, after jury instructions and closing arguments, during deliberations, the jury came out and they wanted to have a readback of Mr. Roberson's brother's testimony, Richard Roberson's testimony. Now, his testimony was very important to the defense case because it gave a version of self-defense consistent with Mr. Roberson's. Now, as opposed to exploring that avenue and helping the jury further flush out credibility, which version of self-defense to look into, the defense counsel said, no, we don't want to read back of the testimony. There was no further explanation given to my recollection. Why they would-
Was that part of the evidentiary hearing or no?
It was not. It was denied without.
So that was summarily denied?
Correct.
And would you remind me the grounds for that? Prejudice or
It wouldn't have prejudiced, it wouldn't have made a difference, pretty much.
wouldn't have made a difference if it was read back? You know, if the jury asked for something, and it's, you know, one of the witnesses to the,
A defense witness.
yeah, right. Okay.
You referred to convictions that were 15 years old or longer?
Somewhere, correct. And unlike in a civil case, there's a remoteness argument there under 403. In a criminal case, you know, those convictions still come in. The state has ability to rehab, but, you know, we'll never know exactly what role that would have played because it was never brought before the jury. In a hotly contested case where credibility was a crucial issue.
Parties ultimately agreed that all this to be read to the jury.
That's correct. And the defense attorney elected specifically not to have that read back done.
And there was, because that wasn't part of the evidentiary hearing, we don't have any basis for why the defense attorney would have done that or not done it.
We don't, and what's especially crucial is after the trial court gave a instruction that they're not going to read back the testimony, a juror says, in the transcript, you've got to be kidding me.
Yeah. Mr. Crawford, you're at your 15 minutes. I know I cut you off on cumulative error.
Yes, ma'am. I can address that.
You still arguing the point about the 5-year offer?
I'm just going to rely on my arguments in the brief. It is a credibility issue, which, and I understand the trial courts, you know, that this court can't weigh credibility on appeal. I don't want to say that I concede on that issue. I will just leave it as argued in the initial brief.
All right, thank you.
Thank you.
Good morning, Your Honors. May it please the court. My name is James Hellickson, and I represent the state of Florida, the appellee on this matter. As Your Honors are aware, this is before the court on the denial of a motion for post-conviction relief. The post-conviction motion raised 5 grounds, and there was also a direct appeal in this case where they raised 5 grounds. For the direct appeal purposes, they raised the denial of the motion for immunity and judgment of acquittal, that the defendant appellant acted in self-defense, that there was fundamental error not to have Richard Robertson's testimony read back, and then there are a couple other issues that weren't also raised and that were separate from the post-conviction motion.
What strategy might be behind the defense attorney's decision to go along with not reading back a defense witness's testimony? How could that possibly be a reasonable strategic decision?
Well, Your Honor, as far as that was brought up at trial where they discussed this, the trial court indicated that it expressed some concern with this court's decision in Gormity, where once you start reading back testimony, where do you start and who gets to decide where it stops? So that was discussed. And so they're going through this discussion about having this testimony read back. There's discussion about will reading back one witness's testimony emphasize that witness's testimony to the exclusion of the other witnesses. And one of the witnesses who testified was also the defendant. So there's the defendant's.
Well, but the jury only asked for this one witness.
Correct, both his direct and cross-examination. So the question then became is where does it stop? Do you read it in full? Do you stop somewhere in between? Does the jury get to decide where to stop? Does a judge decide where to stop? And so they're having this discussion and defense counsel says, well, I'm
So
against
then
the
you just decide not to do it at all
Well,
because it's a hard question?
the defense attorney said, I'm against the read back altogether.
I know. How is that defensible?
Well, Your Honor, it goes again to their determination at trial, which we don't really second guess in post-conviction. And so there is a reasonable strategy, because if you're concerned that it's going to highlight a witness to the exclusion of the others, including the defendant, that is a reason why you might not want to have one witness's testimony read back. And if you look at this court,
Maybe that's why you have an evidentiary hearing.
that's also a possibility, Your Honor, if he says, but again, the trial, he says, I don't want this read back.
Now, if that's alleged to be ineffective,
Correct.
right? So then the question becomes, for it to be ineffective, I mean, was it a reasonable strategic decision? Wouldn't that be something to be fleshed out in an evidentiary hearing?
Not necessarily, Your Honor, if it's conclusively refuted by the record.
Well, wait, how is it conclusively refuted by the record? The record shows, as you have just acknowledged, that he affirmatively said, I don't want it read back.
Mm-hmm.
So we know that, we just don't know
Right.
why.
Correct. And so then the question becomes if that is, so the question on post-conviction, is that sufficiently unreasonable to bring us to deficient performance? And so the question then becomes, if you answer that question in the affirmative, you say, well, does it have some effect on the trial? And for summary denial, obviously you're looking at, is the claim sufficiently pled? Is this, something that post-conviction counsel, is this a post-conviction? Is it trial counsel error? Or is it the court saying we're not going to do it? And so I think when you look
I
at,
mean, I think everyone's agreed that defense counsel said no. I don't
Correct.
want it back.
correct. And so from there, then you look at, did that have an effect on the trial? Or was it, I guess then the question becomes is, right, would that have affected the trial at all? And I think that it's,
Well, the jury was interested in hearing it, and it was a defense witness.
correct, Your Honor. But again, it goes to, at the
I
time of,
mean, there's always a degree of like, I don't want to use the word speculation, but it's what's coming to mind, when you have to evaluate what would have been the effect on the trial. That's true in every post-conviction analysis of prejudice, right?
right, and that's why you kind of avoid the hindsight, because everybody would have said, well, if I had done this differently, or I could have done this differently, I could have done that, could have done that, should I have agreed to this or not? And I think that's what defense counsel was doing, is they were just saying, well, instead of going through this whole, decisive of when do we stop, when does it become prejudicial, is it harmful to emphasize the brother's testimony to the exclusion of all other witnesses, that is a reason.
Well, what's your analysis of how the brother's testimony could have, let's say it was read back, how it would have harmed the defendant's case?
Well, it depends on, again, on where they stop, because
Just tell me, like, worst case scenario for the defendant.
well, obviously we don't know,
Which part of it would have been detrimental to the defense? Which part does the state contend would have been detrimental had it been read back?
well, Your Honor, I'm not sure which part would have been detrimental had it been read back, because I'm not sure what the emphasis, again, where it would have stopped. So if the jury
Let's say
says,
the worst part of it, or all of it. I mean, you're arguing that it could have been detrimental. Well, then you've got to be able to point to something in that testimony and say, had the jury heard this again, this would have been bad for the defense. I mean, shouldn't you be able to tell us that?
as to which specific part of it,
What part of the defense witness's testimony, the brother,
mhm.
would have been, oh, if the jury got to hear it again, it's like, oh, that's bad. I mean, they might have decided they didn't believe him, but.
Again, you go back to, is this highlighting his testimony to the exclusion of the others? And I think that is a reasonable decision to be made at the trial.
Well, but we're here on the attorney's decision.
Correct.
To not have it read back.
Correct. And I think that was part of the discussion.
This was a defense witness.
Correct. And again, the defense attorney would be in the best position to understand how that would
Well,
have
if he
been.
was worried about the testimony of the brother, maybe he wouldn't have called him at all. as a
Then it-
witness.
Then again, you get into, you get into the hindsight is, well, if we had presented one more witness, would have tipped the scales. And here, they called all the witnesses, they had the
There were competing
discussion.
versions of the events, and you had the victim and his family, and then you had the defendant and his family, and there's competing versions, and, I mean, the jury had to choose between the two, and they wanted to rehear one of them.
Correct, but
I mean, it could have gone, I mean, I'm sorry, go ahead.
well, what I was gonna say, Your Honor, is if you look at the competing, the evidence is pretty consistent. There was a shooting, the victim was shot by the defendant. The question becomes is, was the defendant acting in self-defense? And if you look at that aspect of it, then the defendant's testimony is gonna be the most critical, because he's gonna be able to testify as to what he was thinking at the time. The brother might be able to testify to some of the events, but he's not gonna be able to testify as to what's in the defendant's mind at the time. How in fear was the defendant? The brother can't testify to that aspect of it.
And isn't it true that the defense attorney sized up the witness's credibility? He might think this guy's a really bad witness. You read that back, he'd come across even worse the next time.
Of course,
Well, but, he somehow got through this testimony, let it sit, and he thought about the option. I mean, it used to be readbacks were not mandatory, now they're mandatory if requested.
Mhm.
If you back off, we tried to, I think it was Roper versus State, made it mandatory, and then it became a rule. So, it doesn't mean the defense attorney doesn't have the right to say, okay, I changed my mind, I don't want it. Maybe he heard something during that argument to make him, I mean, I don't see that as a 38-50 automatic, just because he said, okay, we don't have to read this back, it might hurt me. We don't have to figure out the reason why he did that, as long as there's some rational basis for it, somewhere in the record.
correct. And then you also have to look at, would that have affected the trial overall? Because you're looking at the two components under Strickland, you're looking at the deficient performance. So first you'd have to say, you'd have to answer that, this would have been deficient performance not to have this testimony read back. And I on the facts of the case, having the defendant's testimony, I don't think it gets to that first prong.
You really haven't said what the testimony was. That, I mean, I asked you what about his testimony might have been detrimental to
And
the defense, and you weren't able to articulate what specifically in his testimony, could possibly have been given the defense attorney pause in having it read back when the jury wanted to hear it again.
correct, Your Honor, I can't point specifically to what would have been harmful in the testimony. I can point,
I'm assuming nobody came up with any case law that says that failure to, the objection to the readback is ineffective assistance.
not at trial, not at trial, Your Honor.
The defense lawyer has pretty wide latitude as to what he wants to put before the jury.
Correct, Your Honor. And the case that was discussed at trial was this court's decision in Gormity. And if you go back through the record at trial, you'll see where they discuss that case in depth. And they say, okay, once we start this read back, because in Gormity, they agreed to the read back. They start reading back and the jury says, we've heard enough, and they stop it. And this court said, you can't do that. You have to have, the jury can't decide when to stop the read back. And so that was the kind of the linchpin of this argument is, okay, once we start it, when do we stop it? And then also now we've highlighted this particular witness. What do we do with the other witnesses? Do we then have a discussion as to doing anything with their testimony? Because now we've highlighted the brother's testimony
Well,
over.
that doesn't make any sense because the jury didn't ask for that. But can we move on to another
Yes.
issue? I'd like to hear what you have to say about the summary denial of the testimony that the victim offered to drop the case in exchange for money.
Yes, Your Honor. And if you look at this particular claim, and I will admit that I think I was a little bit incorrect in the answer brief. I argued that this is going to be, there was a lot of discussion on this being collateral impeachment evidence. And the more I looked at it, I think the claim is insufficiently pled, and I'll tell you why. Because in the motion for post-conviction relief, they want to get in statements that were made to this particular landlord, but there's nothing to indicate how he's connected to the Robertson family. There's no indication that he's an agent for them. There's no, and so
Well,
if,
why would he have to be? If he just overheard the statement?
well, I don't think it's he overheard it. I think it's he's making the statement directly to them. And if he overheard it, it would be hearsay if it pertains to Robertson and his family, and it would be admissible. It would be getting into, instead of being impeachment, it would be getting into substantive evidence if it pertained to him. So I think what you're getting into more is that you're getting into this quid pro quo that occurred before trial that could really have a detrimental effect in trial, because now you're going to have a mini trial about this per se quid pro quo that occurred before trial.
Okay, well,
Mhm.
you gotta, let me
Yes, sir.
back up, because you said you should have argued that it wasn't sufficiently pled, would you? But you didn't?
That's correct, Your Honor. I argued more like the post-conviction court did, that it's collateral impeachment. I do think it's a collateral matter. I do think it was properly, that it was properly excluded from trial. So I think the denial of the motion is overall correct.
Wait, it was excluded? I thought he didn't call the witness.
Correct. So I mean, it was properly summarily denied is what I meant to say, Your Honor. I apologize for confusing that.
And what was insufficient about the way it was pleaded?
Your Honor, there's no allegation as to what the bias would have been. We don't know. There's no indication that the witness's testimony was false, that the victim's testimony was false. There's no indication that had this come out that anything would have changed at trial. If you look at the Roberts case.
Well, credibility is crucial in this
Mhm.
context. I think the argument is if you have a victim who's willing to drop it in exchange for money, you know, his testimony that would negate self-defense is maybe less than credible.
Well, Your Honor, I think that just goes to prove that he and the defendant agreed to drop the case before trial. I don't think it has any bearing on the self-defense argument. And I think that's why you risk really opening the door to this collateral matter.
I think it's credibility that it goes to. Like, we can't, you know, this guy has had a motive here.
But that's what wasn't alleged in the motion. They never alleged what the motive was. They didn't say that he was going to offer false testimony. If you look back at the Roberts case from this
No,
court.
I think the notion is that he did offer false testimony.
That the fact that the evidence that
I mean, if you're trying to attack his credibility, and the thought underlying that is his testimony is not accurate.
that there really was this quid pro quo before trial and he denied it at trial. Is that what you're saying that the false testimony is? That he made the offer to the landlord to say, I'll give you 10, or I'll communicate to the family, the Robertson family, that I'll drop the case for $10,000. And then he says at trial, no, I didn't do that. Then they want to bring in the fact that he actually did that. Is that what you're suggesting is the?
I'm not suggesting anything. What I'm suggesting is credible. Their argument is that by failing to call this witness to give this testimony, the defense gave up an opportunity to challenge the credibility of the victim.
Well, I don't think that's true, because sometimes the best evidence is the best strategy is to cross-examine the witnesses. And I think that by getting into this pretrial agreement or this pretrial offer really opens up the door to getting into this collateral matter. And if you look at the Roberts case that this court decided, so the concern there, and if you plug that into kind of what happened here, so what Roberts was concerned with was it was the defendant who wanted to introduce this, the offer of the $20,000 to open the store against one of the Williamsburg witnesses. And this court said, well, we can't determine if the defendant was really precluded from testifying because of what trial counsel did. So in this case, it was the defendant who wanted to introduce that statement. I think he could have. And he would have been the best person to introduce that statement, but they don't want to call, and they're not alleging that trial counsel is ineffective for not introducing this statement through the defendant. They said they should have called a third party. And if you look at the Roberts decision, this court suggested that the statements that from the defendant's wife to the party would have been hearsay. And this court suggested that maybe the trial attorney could have further investigated the case to find some type of relevant admissible evidence. And here, I think that had this come through the defendant, this court would be looking at an entirely different scenario, but they were trying to get this in through the landlord. And so there's no indication on how this was conveyed to the landlord or how the landlord knew about this out of court supposed quid pro quo to exchange the money.
That's why you have an evidentiary hearing.
And I think that opens up the case, because even if it's going to impeachment, it still has to be governed by 90.403 of the evidence code. And
Don't
there's
you need the evidentiary hearing to develop that? I think
Not
that's at least a
Oh,
first
sorry.
component of the argument.
It is, Your Honor, but not necessarily, because if it opens up that collateral matter and is excluded under 90.403, as the 5th District concluded in, well, I'm sorry, I take that back. The 5th District in Nelson decided that the trial court properly excluded the evidence of the civil motive under 90.403. It wasn't dealing with it on a post-conviction claim. It decided on a direct appeal. But they said, yes, this was properly excluded in limine because it failed the 90.403 balancing test, and that the substantive probative value was substantially outweighed by the danger of presenting a confusing issue. And I think you run into a little bit of that here, because this would have presented a confusing issue. Because now you have, is this really, was this made? Then you get into what's the basis of the quid pro quo? Was he offered money to drop the charges? Was he offered money to testify falsely? Was he offered money to?
Well, and again, if you had an evidentiary hearing, that could be developed.
But again, I think it's properly denied as, excluded under that, and you get into this
I mean,
real collateral.
an evidentiary hearing isn't granting relief, it's just more fully developing the record, and then the trial court can make that determination.
Correct.
It's not saying he gets a new trial, it's just like, we're gonna flesh this out, because it's not conclusively refuted by the record that it was, whether it was prejudicial or whether counsel was ineffective.
And I think it just goes to show that, that it wouldn't have affected, there's no prejudice to it, because it's a complete collateral matter that would have detracted from the trial itself.
I get it.
Yeah. And I just want to point your honor to the reply brief at page 3. You'll notice how this kind of gets into he said, she, it's going to be a he said, and it's just going to go back and forth, and you'll notice where does this stop? And I just wanted to note that for the court.
And you're at 20 minutes.
Okay.
So that's a great.
Yes, Your Honor. And the state would respectfully ask this court to affirm the trial court's decision. Thank you.
Thank you.
Oh, sorry.
You good?
Yes, Your Honor. Sorry.
All right.
May it please the court. Your Honors, we have a situation here where it's an aggravated battery case. 1020 life is obviously at play. 20-year minimum mandatory sentence. You have two versions of self-defense by two different groups of family members. So credibility is a crucial issue. In determining credibility, you have issue number one, which is to drop the case in exchange for $10,000 that the victim allegedly made. Now, what opposing counsel just argued is exactly arguments the state should make at an evidentiary hearing where this can firmly be flushed out and a determination be made how this was specifically brought about, how it was made, things of that nature. That's for an evidentiary hearing. The law in Florida is clear that in order to have a facially sufficient motion for failing to call a witness, we have to identify the witness, which we did. You have to give proposed witness testimony, which we did, that the alleged victim offered to drop the case in exchange for $10,000. How this prejudiced Mr. Roberson, because clearly in a hotly contested case where credibility is an issue, this goes to Mr. Barron's, the alleged victim's bias or motive to testify falsely for money. Furthermore, it also, since defense counsel asked the question during the trial, it goes to a prior inconsistent statement, both of which the jury is specifically advised of in weighing credibility after closing arguments. In terms of the failure to impeach with the prior convictions, the issue for this court is prejudice. The trial court didn't come out and specifically say that defense counsel was deficient, but defense counsel conceded, I knew about them, they were in the deposition, I should have impeached them with them, I didn't. On that ground alone, I would submit to this court, since there was an evidentiary hearing on that issue, and since credibility was a crucial determination, it's ineffective assistance of counsel. As to the readback, Judge Valenti mentioned that, what is the rational basis for denying the readback? And Judge Black, you mentioned that a defense attorney has wide latitude. Again, those are two things perfect for an evidentiary hearing. In the record itself, we don't have the rationale for the defense attorney to not request a readback. But in a hotly contested case where credibility is a crucial issue and the jury wants a readback of a defense witness's testimony who provides favorable testimony to the defense, which includes the fact that Mr. Roberson, the defendant in this case, was being attacked not only by the victim, but the victim's brother, not to mention the fact that there was a very large group of people there. It was a high crime area, which was the necessity to have the firearm in the first place. All of those factors mitigate toward a self-defense claim. That's precisely what an evidentiary hearing should be about. Furthermore, as it relates to in terms of the cumulative nature of the ineffective assistance of counsel, you have the jury given a list at the end of a trial of what to look at when determining credibility, which is so important when you're determining credibility in a criminal case with these stakes. The jury is specifically advised to consider felony convictions, crimes of dishonesty, whether or not a witness had an interest in how the case is decided, and additionally, whether someone made a prior inconsistent statement. The jury heard none of those in this trial of the most crucial key witness, which would be the alleged victim in the case, Mr. Barron. Based on that, I'd respectfully ask this court to reverse and remand for either a new trial as it relates to the grounds that were heard during the evidentiary hearing, and or a reverse and remand for at least an evidentiary hearing on the issues that I've raised.
Thank you.
Thank you.
Both. All right. Next case this morning is Geddes versus Pinellas County Property Tax.